I call to order the meeting of the Bills Committee. Let's first invite representatives of the administration to come inside the conference room. Thank you. First, let's deal with matters arising from the previous meeting. The administration has provided a response to issues raised at the meeting on 17th of February 2025. LC paper number CB brackets 1260/2025 brackets 02. Will representatives of the administration please brief members on the paper? Thank you, Chair. We thank the feedback given by members. At the last meeting, we have submitted detailed responses to 11 issues raised at the last meeting. Let me first address items A and H on national security risks. Safeguarding national security is our primary responsibility. When drafting our redomiciliation regime, we have considered potential national security risks. We have introduced provisions to make sure that at the application stage we have some safeguards to address potential national security hazards. We do thank members for raising issues in relation to Section 820C3. Our policy considerations are these. We need to make sure that the redomiciled companies are not for unlawful purposes or contrary to public interest. Considering members' feedback, we will introduce committee stage amendments to make clear that when there are concerns that the redomiciled companies will be used to endanger national security, the registrar must refuse the relevant application. In fact, the Safeguarding National Security Ordinance has already clearly set out that civil servants are required to safeguard national security. And Section 8.3 of the Safeguarding National Security Ordinance states that the registrar must regard national security as the most important factor and give due consideration to such factor. And therefore, the registrar must, when dealing with redomiciliation applications, safeguard national security. If the registrar considers a redomiciliation application can potentially endanger national security, the registrar must reject the relevant application. We believe the safeguards in existing HKSAR national security legislation as well as the bill should address any potential national security risks. Let me now talk about some certainty in relation to redomiciliation litigation. Some members expressed concerns on litigation arrangements while the companies haven't yet deregistered from their original domicile or their last domicile. We would say this before the redomiciliation date. If litigation has commenced in accordance with 820D1C, it is clear that the ongoing litigation will continue. If there are winding up procedures that are ongoing, the company will not be regarded as having met the redomiciliation requirements. During the transitional period, in accordance with 820D1C, for applicants that have already been issued with redomiciliation certificates and are regarded as redomiciled companies, for the existing proceedings, they will continue. For the litigation that has yet to commence, they may still be commenced or initiated on or after the redomiciliation date. As for where the litigation will take place, it will not only be dependent on the redomicile of the company. There are other factors to be considered, and the courts will determine whether they have jurisdiction on a particular case. So it is not necessarily the case that all litigation will take place in Hong Kong upon redomiciliation. As I said before, the litigation that has commenced will not be affected. As for redomiciled companies that have been deregistered, their situation will be similar. Let me now talk about the 120-day period. When setting the 120-day transitional period, we have considered several factors. We have considered stakeholder feedback. We had also referred to our experience in redomiciliation of funds. We have also referred to the practices in other jurisdictions such as Australia and New Zealand. They don't even have a deadline for deregistration. So for us to set a 120-day transitional period, it has considered the legal effect of redomiciliation, and we believe with this we will balance the different factors. Yes, Ms. Carmen Khan. I have 2 points to raise. Should I wait until they're done, or should I ask them now? I want to ask about Section 820C3. I think the administration for taking into consideration members' feedback to change the word to must from may. I think the administration is quite clear, not only in their oral reply but also in their written response, that we will be addressing national security risks. But for the record, can the registrar reject the application only citing the reason that there are national security concerns, rather than giving more detailed reasons? Often in administrative procedures, reasons will be given for rejections of applications. So is it possible for the registrar to only cite the reason as potentially endangering national security? That would be it. They wouldn't have to give any details, right? Otherwise, I think you have to make clear in law the operations. I also want to check with the DOJ colleague that this is the intent of the drafting. Thank you. Actually, we have talked about this in pages 12 to 13 of our response. In the common law or legislation in general, there is in general no specific requirement for departments to give reasons. But in general, reasons will be given. It would be on a case-by-case basis. If it is related to national security, if we provide reasons, will it compromise national security? We probably will not even give reasons. But the general principle is that we will give reasons. The registrar, when exercising powers under the bill to deal with redomiciliation applications, whether it is national security related, one may still lodge judicial review against the decision made. Ms. Carmen Khan, any follow-up questions? The administration said that they talked about responses in pages 12 to 13. If I understand correctly, that means if there are national security concerns, the registrar would be inclined not to cite any reasons. Will you give reasons still, just not this reason? From your answer, it seems that when it is national security related, you will not give any reasons. Do you have any legal basis for this? You said under common law, you are not required to give reasons. Is that correct? I also want to ask if can the DOJ colleague confirm that in case law, this is justifiable? Thank you, DOJ colleague. Let me confirm that under common law, there is no requirement to give reasons under administrative processes, but in general, companies registry for incorporating companies, if they are rejecting the application, they will in general give reasons. And it's the same for bill. But let me say this for H3 in the response. Item H3. If the registrar considers that the reason may be national security related, the registrar may not give reasons. And even if the registrar does not give any reasons, it will not be against the law. I don't understand where the DOJ colleague is referring to. Oh, she's referring to what is on page 13. 12 and 13. Alright, I will ask my other questions later. Okay, Deputy Secretary, please continue. I talked about legal proceedings. Now I will talk about items C and J, the other CSAs that we are going to introduce. We do thank members' suggestions. For section 139.6, we will amend the definition of specified date, and we will replace it with material date that is found in another section. There is also another concern that was raised by members on the definition of eligible members. Now, for companies, if their original domicile does not have any legislation, nor does their constitutional document have any threshold for consent of members for redomiciliation, we will spell out with the CSAs that there is a 75% majority threshold, and the resolution may be passed at a meeting or by circulation. So that's it for our response. If members have any other questions, we are more than willing to answer them.
Members who intend to ask questions, press the request to speak button. 4 minutes each, including questions and answers. Ms. Carmen Khan, thank you. I'd like to ask a question in relation to A20D bracket 2, referred to by the administration during the oral description, and that is a deregistration will not impact on any legal proceedings already commenced. However, during application, I'd like to know whether there is any requirement to disclose legal proceedings in progress so that we can be informed of ongoing legal proceedings. Well, even though there is any disclosure, now I'm not talking about the timetable of disclosure, rather a certificate of redomiciliation has been granted, but then legal proceedings arising during the 120 days before the registration may not be unknown to us. So I'd like to know whether the applicant is required to disclose legal proceedings started after the certificate of redomiciliation. Well, at the point of application, our greatest concern is whether there is any legal proceedings related to winding up, related to creditors. This is a very important consideration for us in deciding whether the application should be granted. So during the application, the applicant is required to declare that there is none such legal proceedings going on. I will invite the company registry to supplement. Thank you. In Schedule 6C, 2F page, we require the applicant to provide a piece of legal advice by a legal practitioner of the original domicile. And in the legal advice under Roman letter 9, the applicant has to confirm that at the original domicile, there is no legal proceedings involving winding up of the applicant or any liquidation. And then in Roman letter 10, the legal petitioner has to confirm that there is no legal orders requiring liquidation or winding up of the applicant at the original domicile. What is the page? I'd like to know the page. In the blue bill, page C3929. 3929. 3928 is the Chinese text, and C3929 is the English text, so Roman letter 9 and 10. So you only talk about winding up or liquidation, but the Deputy Secretary referred to debtors or creditors as well. So there will be confirmation by a legal petitioner. Would there be requirement for disclosure of all related legal proceedings, because the registrar will only use winding up as the threshold? What about debts and involvement of creditors? Will those points be made known to the registrar? Because if there is a lawsuit against the applicant, the financial position may be affected. For instance, will you require the applicant to make a declaration, because this may not be covered by legal advice? Can there be we will provide a written reply to the questions by members. If there are no further questions in relation to the paper, we move on to the next item. We were In the course of clause-by-clause scrutiny last time, we were dealing with we will start 126 or 176. Our legal advisor will help us to study the English text as well. So we'll start with clause 80. Thank you. May I refer you to page 176 of the Chinese marked up copy, and that is clause 80 of the Blue Bill. We're dealing with part 3. Part 3 to deal with subsidiary registration to be amended under the company's registry. So I will go through the clauses one by one. On page 176 of the markup bill is about amendment to Section 3, unless the company has never got any accounting transactions since its domiciliation. So if under new Section 830C1, a company is domiciled in Hong Kong and there is no financial or accounting transactions since that date, then Section 3 will not apply. Page 177, and that is clause 81 of the Blue Bill, and that is subsidiary registration B. The company has to specify the total donations. It will not apply to wholly owned subsidiary company in Hong Kong. Now, the scope of application will not cover a wholly owned subsidiary company of the re-domiciled company. Page 178, Section 82 of the Blue Bill. This amends the title of subsidiary registration J. So this will apply to companies that is applicable to Section 6. So for non-Hong Kong incorporated companies, they will be covered. And I'd like to refer to clause 83 that will amend J to introduce the definition for place of incorporation. Page 180 to 181 of the marked up copy. Clause 84, and will amend 3 of subsidiary registration J. This will include all the information required under the application, and all references to place of incorporation will be replaced by place of domicile. Marked up copy 182 to 183, clause 85, amending subsidiary registration J. Documents to accompany application for registration. We've added a new section to specify how the provision should apply to non-Hong Kong incorporated company in Hong Kong. Now, there must be all documents for under the law of the place. Page 184, and that is clause 86, amending Section 7 of subsidiary registration J. We will add 1A. For the purpose of subsection 1, the certificate issued under the law of the company's place of incorporation certifying that the company is registered as a company under the law of that place. So if a company has been redomiciled, then referring to a certificate of the latest place of domicile. Clause 87, that is Section 9 amending particulars to be contained in annual return. So we have amended references to 所在地 so that the definition under Section 2 can apply here. Page 188 of the marked up copy, clause 88, that is about interpretation of Section 10. Now, this will supplement references to a registered non-Hong Kong company includes a redomiciled company to which Section 790 of the ordinance applies. So they will apply to redomiciled company to which Section 70 of the ordinance applies. Now, starting from clause 89, we will be amending companies' fees regulations, sublet K, with added provisions to cover fees payable in relation to registration of companies or for registration of documents. We've also added regulations in relation to search of documents. Subsection clause 90. Fees for inspecting or obtaining documents or information. This is based on a cost recovery principle. Page 192 of the marked up copy. We have added fees for making copies or images of documents. Marked up copy 100. Ms. Carmen Can. Chair, thank you. I have a question about fees. Now, the administration told us that fees are calculated on a cost recovery basis and also comparable to other jurisdictions so that the fees will not be too high, affecting our competitiveness. Our question, however, is will the fees be too low? We talk about $6,000 and we're told that the fees were very competitive and it would be reviewed from time to time. I'd like to know whether you will specify the frequency of review. From time to time, we do review government fees and charges. There is no need to specify that in the legislation. And after the regime is in place, taking into account operational experience, we will consider the actual costs involved, and that the fees will be reviewed on a regular basis based on the cost recovery principle. Any supplement from Carmen? Now, my question about the costs are done, but in relation to the administration's response, I have just finished reading page 19, the decision to refuse an application. If a reason is not given, whether it is because of national security concerns, can be subject to judicial reviews. I have some concerns here. Can the DFJ clarify? Because a similar question was asked last time. Decisions related to national security issues or certificates by the CE to confirm that it is a national security issue will not be subject to any judicial review. How come it is not so here? I'm a bit confused. Can the DFJ please explain? Supplement or DFJ, please? Thank you. Yes, last time a member asked whether all decisions related to national security would not be subject to any judicial review. In fact, in the Hong Kong national security law, Section 14, it is stated that if a decision is made by the Committee to Safeguard National Security in Hong Kong, then the decision is not subject to any judicial review. However, for the provision here, we're talking about decision by the Registrar of Companies. So the decision is by the registrar. It is not one made by the National Security Committee in Hong Kong. So even though a decision made by the registrar is based on national security concerns, it can still be subject to a judicial review.
Ms. Kamen Khan. Well, when will your administrative decision be made? That is very important. And according to the administration's response on page 13, I have some reservations that the decisions, whether it's national security related, would be subject to judicial review. Can't you let the committee decide on this? Is there any room for you to accommodate the committee's operations here? That is the Committee for Safeguarding National Security of the HKSAR. And if the decision is up to the committee, then it would not be subject to judicial review. I think in general, for other jurisdictions, when it is national security related, it should not be subject to judicial review. In fact, Singapore's regime works in the sense that there would be an appeal mechanism. In Australia, there's not even an appeal mechanism. The UK's proposed framework would not have an appeal mechanism either. So when you consider different practices in different jurisdictions, there is no unified practice. I think we can have our own practices. With redomiciliation, there should be comprehensive consideration. I don't think the decision should entirely be made by the registrar. You are talking about you would rely on Article 14 of the National Security Law, but is that enough? Can you reconsider your response in page 13? You may not be able to provide a response right now. I think you may have to communicate with another division of the DOJ to make sure we are dealing rightly with the national security concerns. And as I said earlier, in other jurisdictions, we don't even see an appeal mechanism. When it comes to national security concerns, I think not allowing judicial reviews is the right way to go. DOJ, perhaps you do not have to give an answer right now. You can give a written response after the meeting. Thank you. We will review this after the meeting. I think, simply put, when it comes to national security concerns, is it the case that the decision would be solely made by the registrar? And if you are not citing any reasons, wouldn't it make the application more vulnerable to a judicial review? I think rather you should have a national security issue handled by the Committee for Safeguarding National Security of the HKSAR, and that would be it. I think that DOJ can review the drafting and provide a written response to the issue raised by Ms. Kamen Khan. But let me say this. For this bill, it only empowers registrar to make a decision. It doesn't mean that the power of the registrar would prevail over Article 14 of the National Security Law, but we will communicate with colleagues in the other division before we give a written response to the members' issues. Thank you. Please proceed. We were on page 198 of the marked up copy in Chinese. We are talking about fees for downloading images. We have Roman numeral 1 for lodging a notice relating or documents relating to charges. We also added a reference to section 338A so that charges for registering companies would be included here in this schedule. Next, page 203 of the marked up copy in Chinese. These are some fees for obtaining records from the company's registry. Now, for copies of records of companies for redomiciliation forms, the fees would be in line with other documents. Next, just like for the documents of charges, if one wishes to obtain documents relating to charges, the copies of such documents, we have added a reference to section 338A so that the fees for the relevant charges can be covered in the schedule. Next, page 213 of the marked up copy in Chinese. On inspecting or obtaining documents relating to redomiciliation forms, again, the fees are in line with those for other documents. Next, page 219 of the marked up copy in Chinese. For obtaining images relating to documents of charges, again, we have added a reference to section 338A. Next, page 223 of the marked up copy in Chinese. Fees for registering charges. We have made an amendment repealing any specified charge described in section 334 of the ordinance and substituted it with a charge, so that this would apply not only to existing charges but also charges registered under Part 16. Next, page 225 of the marked up copy in Chinese, clause 92. It amends chapter 622M's title in Chinese. We are making this change to tie in with the definition of place of incorporation. Next, clause 93. Oh, let me first say that chapter 622M is non-Hong Kong companies' disclosure of company name, place of incorporation, and members' limited liability regulation. Section 2 has been amended to introduce the definition of place of incorporation. Next, page 228 of the marked up copy in Chinese, clause 94. It amends section 3, display of name and place of incorporation at business venue. We have amended the heading as well as the contents to have the definition of place of incorporation included. Next, clause 95, it amends section 4, name and place of incorporation to appear in communication documents. We have made amendments similar to what we did in clause 94, that is to section 3. Next, page 230 of the marked up copy in Chinese, clause 96. It amends section 6, duty to disclose certain matters while in liquidation. Again, we have made similar amendments to previous sections to include the definition of place of incorporation. We have finished scrutinizing the amendments in Part 3. Now we'll go into Part 4 with the domiciliation regime. In Part 4, we will make related amendments to 39 pieces of legislation to make sure legislation in these ordinances will apply to redomiciled companies. We are introducing mostly definitions. We have also provided for provisions relating to Hong Kong incorporated and non-Hong Kong incorporated companies so as to make sure they are regarded in the same way once the non-Hong Kong incorporated companies are domiciled. We will also make changes to match the special circumstances of redomiciled companies. Pages 231 to 237, clauses 97 to 101, we have made amendments to trustee ordinance. Page 231 of marked up copy in Chinese, clause 97. In Chapter 29 trustee ordinance, we have amended section 2 to add definition of redomiciled company. Next, page 232 of marked up copy in Chinese, clause 98. It amends section 41Y relating to transfer of movable property not affected by foreign law of inheritance. One of the conditions is that each trustee must be incorporated in Hong Kong or is registered as a body corporate. If they're incorporated outside Hong Kong, they must be managed and controlled in Hong Kong. And clause 98 would amend this section to include redomiciled companies. And for outside Hong Kong, it would have to exclude redomiciled companies. Next, clause 99, it amends section 68, transfer of trust securities in name of official trustee. For any public company or corporation established in Hong Kong, the existing legislation says that they must submit relevant affirmations or oaths. Once they have submitted such documents, they can transfer the documents to those with another name. Excuse me, Mr. Lam Sen Kung. The speaker's microphone is not on. I want to ask about clause 6, section 68's amendments. You asked about, it says here, specified entity. What does it mean by any specified entity? Well, we would say this before. It would say any public company or corporation established in Hong Kong. We have repealed it and substituted it with a specified entity because we want to include also redomiciled companies. So we will introduce in subsection 2 of this section a specified entities definition to include redomiciled companies. Can you talk about what specified entity means? We are referring to C3967 in the blue bill.
Page C3967. So 指明實體 is specified entity. Oh, all right. Okay. Any follow-up? I'm good. Please go on. Now we're on page 240 or clause 100 of the Blue Bill. That is about section 77. That is application by company to be registered as a trust company. Now it applies to all Hong Kong incorporated company and also not private company. Clause 100 amends section 77 to cover a re-domiciled company. Now page 273, and that is clause 101 of the Blue Bill. Section 95. Under certain circumstances, the FS can appoint inspectors for the management of a company. This must be related to the incorporation of a company. If a person has been convicted of fraud or misconduct, etc. So this clause amends section 95 to cover a trust redomiciled company. And any person related in the control of the company if has been convicted of misconduct or any fraud, then the FS can also exercise its power under this section to appoint inspectors to look into the business of the company. Page 238 to 266 of the marked up copy, clause 102 and 162 of the Blue Bill, that is amendments to Companies Winding Up and Miscellaneous Provisions Ordinance 234 to 240, and that is clause 106 of the Blue Bill amends the interpretation section of Cap 32 to add a definition for redomiciled company. For consistency's sake, we've also added new definitions, including a redomiciled company and the day of domiciliation, etc. They are all linked to the other definitions. And we've also updated the references here for clarity's sake. Marked up copy 241 to 242 relates to Section 38B of Section 32, advertisements concerning prospectuses. Section 38B1 is a technical amendment, and that is a company, whether it is incorporated in or outside Hong Kong, and whether or not it has established a place of business in Hong Kong will be covered. This reference has taken reference from the definition under Section 2 in the same ordinance for clarity's sake. Page 243 of the marked up copy, clause 106 of the Blue Bill. Under Section 43, prohibition of allotment in certain cases unless statement in lieu of prospectuses delivered to registrar. Application covered companies by share that have not published any prospectuses. Now we are going to amend Section 43. If it applies to a redomiciled companies, then it will apply to the point of redomiciliation of the company, not its date of incorporation. Clause 105 of the Blue Bill, Section 177 of Ordinance 32, circumstances in which company may be wound up by court. Now, if a year from its incorporation or suspends its business for a whole year is repealed. Now, if this clause is to apply to a redomiciled company, it would be 1 year after or suspends its business for a continuous period of 1 year beginning on the day falling after the specified date. Page 248 of the marked up copy, clause 106 of the Blue Bill, Section 374, liability where proper records not kept. It should be 2 years preceding the date of winding up. And accounting records are not properly kept, then the senior executives of the company will commit an offense, and we will amend this. If it is applied to a redomiciled company, then it will be 2 years immediate before the date of redomiciliation or the date of winding up, whichever is shorter. And if the accounting documents are not properly kept, then the senior officials commit an offense and can be liable to a fine as well as imprisonment. 249 of the marked up copy, clause 107 of the Blue Bill. It amends section 327A of Cap 32. Overseas companies may be wound up although dissolved. So this clause will not apply to a redomiciled company. And also the title and the content are amended. So instead of overseas company, it will be certain companies incorporated outside Hong Kong. Marked up copy 258, clause 108 of the Blue Bill. Is about part 12 of Cap 32 is about restriction on sale of shares and offers of share for sale. In this part, a reference to a company incorporated outside Hong Kong does not include a redomiciled company introduced under New 341A. So redomiciled companies are not included. Page 511, marked up copy, clause 109 of the Blue Bill. Section 360BA of Cap 32. If the Seeing Council is satisfied that the company is being formed to evade the society's ordinance, then the registrar may be ordered not to accept the application. We will add new 360BA to empower the Seeing Council to order registrar to refuse registration if satisfied the application to redomicile is made to evade society's ordinance. Page 252 of the marked up copy, clause 110 of the Blue Bill. The existing section 360C empowers the Seeing Council to order company engaging in undesirable activities to be struck off under the society's ordinance. The company may also be forbidden to carry out business in Hong Kong. The company will then be dissolved afterwards. Clause 110 amends 360C to empower the Seeing Council to exercise a similar power to a redomiciled company. Page 254 of the marked up copy. Clause 111 of the Blue Bill. It relates to para 29 of the third schedule. Matters to be specified in prospectus and reports to be set out therein. Clause 111 amends this clause. If a company has been redomiciled after incorporation, Ms. Carmen Ken. Chair, I have a question about 360BA. Marked up copy, page 151. 360BA is a new clause, right? It's a new section, right? There is now in existence 360B. So there is already a mechanism in respect of a non-domiciled company. It is because that in future we will have re-domiciled companies. We have a similar mechanism, right? So 360B applies to ordinary companies. There is already such a mechanism, right? Yes. Now it is not under the Companies Ordinance, rather under Cap 32 Companies Winding Up and Miscellaneous Provisions Ordinance. That means the drafting is the same for the current mechanism. Yes, in order to disallow a company to evade the society's ordinance, the CN Council already enjoys this power. Right. Marked up copy 255 to 256, clause 112 of the Blue Bill. It amends 19th schedule. It's quite similar to amendments related to the third schedule. Contents and publication requirements of advertisements. Information will include the place of registration after domiciliation. Page or clause 113 of the Blue Bill, amending the 20th schedule. The heading will include the main provisions related to that schedule for the sake of the readers. Now, clause 114 of the Blue Bill. The 23rd schedule is about parent and subsidiary undertakings. So the section 5 is about right to exercise dominant influence. 114 states that if after incorporation an undertaking has redomiciled, then we'll talk about something that is allowed under the place of the law of the place where it is domiciled. Clause 115 of the Blue Bill. It amends D1 of subleg J. That is about the report on conduct of directors under section 168I3 of the Companies Winding Up and Miscellaneous Provision. The date was originally the date of incorporation. Now, if it is a redomiciled company, then the date of redomiciliation will have to be filled out. Page 266 of the marked up copy, clause 116 of the Blue Bill, amending section 2 of subleg L of Cap 32. Now, references to old companies will include redomiciled companies. Page 267 to 315 or clause 117 of the Blue Bill amends the insurance ordinance and is subleg under our regulation regime for insurers. There are different requirements now for an authorized insurers in Hong Kong, not incorporated in Hong Kong. Once it is a redomiciled company in Hong Kong, and after it has complied with all the deregistration obligations, it will be regarded as a company registered in Hong Kong. And prior to application to the company's registrar, it has to inform the insurance authority to decide whether after redomiciliation it will have sufficient assets to satisfy all the capital requirements.
Clause 117, we have made an amendment to Section 2 of Chapter 41 Insurance Ordinance to make the definition of company to include a non-Hong Kong company. page 268 of the marked up copy in Chinese. For companies, we have included the definition of financial year in the sense that for profit and loss accounts, we have clarified for redomiciled companies when we are talking about the law under which the body corporate is incorporated. It would be for incorporated companies in Hong Kong. For a body corporate that is a remote domiciled company, it would be the law of Hong Kong. Also, now, Clause 118, Section 3B. The insurance authority may designate an insurer, and the insurers must conform to the requirements. We would have insurers transferring business to elsewhere outside Hong Kong, then the insurance authority may revoke designation. Now, for non-Hong Kong insurers who have redomiciled to Hong Kong, we will say that for once they have redomiciled to Hong Kong, the insurance authority may revoke the designation of the insurer as a non-Hong Kong insurer because they have different requirements from Hong Kong insurers. Now, Clause 119 is about how non-Hong Kong insurers can become redomiciled insurers. They must meet two conditions. One, it has to become a redomiciled company. It also has to deregister from its place of incorporation. The date on which it is deregistered from its place of incorporation is taken to be the date on which it becomes a redomiciled insurer. And before a non-Hong Kong insurer applies to be a redomiciled company, the non-Hong Kong insurer must apply to the insurance authority for a letter of no objection. Please pause here. Ms. Carmen Khan. I have a question about Section 3BA, subsection 2. It talks about when a non-Hong Kong insurer becomes a redomiciled insurer. Say a company that was originally domiciled in Bermuda, they must be deregistered in order to become a redomiciled insurer, and a redomiciled insurer would be regarded the same way as a Hong Kong insurer, and it's different from a non-Hong Kong insurer. So I want to ask why the administration has to wait until the insurer is deregistered from its place of incorporation for a non-Hong Kong insurer to become a redomiciled insurer. I think we have to make clear why this is necessary. Thank you. For insurance and banks, we have the same requirement. For the redomiciled companies, not only should they have become redomiciled companies, but they also have to deregister from their places of incorporation before they can be designated insurers or authorized institutions. We want to prevent the instance in which if they cannot deregister within the 120-day period, we have to revoke their status as redomiciled companies. And if we have allowed them to be redomiciled insurers and institutions, it may be difficult for the relevant authorities to impose regulation on them because there are sudden changes. Thank you. I'll let the IA colleague supplement my answers. As the Deputy Secretary said, it is the case that for redomiciled insurers, they are subject to regulation on the same level as Hong Kong insurers. We want to be clear that the insurers have deregistered before they can be regarded as redomiciled insurers, and then they will be subject to a higher level of regulation like other Hong Kong insurers. Any follow-up questions, Ms. Carmen Khan? Yes. I'm asking because there is a high level of regulation for Hong Kong insurers compared to non-Hong Kong insurers. There are also different thresholds. So when the company's registry looks at a redomiciliation application submitted by banks and insurers, how can the company's registry maintain handshake with the HKMA and the insurance authority to tell them that the companies haven't yet deregistered or haven't met certain requirements and they're revoking their status as redomiciled companies? Can you tell us about the details of the mechanism that registration will only be revoked when there are specific circumstances and what those circumstances are? Insurance authority colleague. In fact, in section 3BA, it sets out in particular that a non-Hong Kong insurer must apply to the insurance authority for a letter of no objection before they register as a domiciled company with the company's registry. So it's just like how Hong Kong insurers would become Hong Kong insurers upon registration. So there is this safeguard essentially. Thank you. For clause 119, it also adds section 3BB. Company incorporated outside Hong Kong that is not authorized insurer to become redomiciled insurer. For the company, it has to register with the company's registry as a redomiciled company and deregister from its place of incorporation. It also has to become an authorized insurer before it can be regarded as a redomiciled insurer. We also have introduced section 3BC some interpretations, place of incorporation, and deregister. And they have the meanings given by the company's ordinance. Clause 120, it amends section 5H, register of authorized insurers. The insurance authority would maintain a register, and it would include the name of every authorized insurer. We have added the parts to accommodate domicile companies so that it would include also the place of domicile if different from its place of incorporation. Next. Pages 273 to 274 of the matter copy in Chinese. Clause 121, it amends section 8, authorization, long-term business, and general business. Section 83E says that the condition is that it should be as defined by section 2(1) of the company's ordinance chapter 622, and it has to conform to the requirements under part 16. But we now have in section 2(1) a definition for redomiciled companies. That's why we will repeal this part we have here right now. Pages 275 to 277 of the matter copy in Chinese. Clause 122, it amends section 9, the meaning of controller. In subsection 3, we have designated insurers. So the requirement will not be made applicable to designated insurers. We have added the part or redomiciled insurer to make sure it does not apply to redomiciled insurers either. Next, clause 123, it amends section 113A, approval of certain controllers of authorized insurers, so that for appointment of various personnel for the transitional arrangements, we need to make sure the approval given before redomiciliation actually takes effect will still apply. Clause 124, we have amended clause 123, it amends section 13A so that we can add a subsection 6C. Page 281 of markup copy in Chinese, clause 124, it amends section 13AC, approval of directors of Hong Kong insurers or designated insurers. If a person is the director of a non-Hong Kong insurer immediately before the date on which the non-Hong Kong insurer becomes a redomiciled insurer, the person is taken to be appointed as a director still after redomiciliation. Clause 125, it amends section 13AE. If one is a key person in control functions, again, the individual is taken to be appointed still upon redomiciliation. Page 285 of the markup copy in Chinese, clause 126, it amends section 13AF. The previously mentioned transitional provisions will be included by this section 13AF's amendments. Pages 287 to 289 of the marked-up copy in Chinese, clause 127. We have added a subsection 5A in section 13B so that if a person is a minority shareholder controller or a majority shareholder controller before domiciliation, they are taken to be approved still upon redomiciliation. Next, clause 128. It includes section 13B 5A and section 13BA. Pages 293 to 294 of the markup copy in Chinese, clause 129. It relates to section 15AAA. It amends this section. This section relates to appointment of actuary. We have repealed paragraph C and substituted it with a new paragraph C so that we can cover the different categories of insurers: a Hong Kong insurer, a designated insurer, and a non-Hong Kong insurer. Next, clause 130. It amends section 15AAD. It is a section relating to person who is authorized insurance actuary under section 15AAA 1A or B immediately before certain events continues to be so. With the amendment, we have added the insurer becoming a redomiciled insurer under section 3BA1. Once an insurer becomes a redomiciled insurer, it would not affect insurance authorities' approval of the actuary. Clause 131, it amends section 15AAE. Person who is authorized insurer's actuary under section 15AAA1C or D immediately before certain events continues to be so. That is, upon redomiciliation, the actuary approval would still be valid. Upon redomiciliation. Next. Page 297 of markup copy in Chinese. Clause 133. We have spelled out before Hong Kong company's definition. As said before, like other amendments, we are repealing the definition as defined by Section 2(1) of the Companies Ordinance, Chapter 622.
係説明咗
Clause 30, Section 31 of the insurance company has defined exempted person. Now, that doesn't include companies incorporated in Hong Kong or incorporated elsewhere, but with a place of business in Hong Kong. So we've added redomiciled companies into the item of companies or person included here. Page 301 to 302, clause 135 of the marked up copy is about section 53B. The IA may disclose information to an authority in a place outside Hong Kong. So such information can include information of a company incorporated in Hong Kong or is a redomiciled company. So we have added redomiciled companies to this section. Page 303 of the marked up copy, clause 136 of the blue bill is about section 64B of the insurance ordinance. We have added 2A. If a licensed insurance intermediary that is a non-Hong Kong company later has become a redomiciled company, the licensed insurance intermediary must notify the authority in writing of such fact within 40 days after it becomes a domiciled company. Thank you. Legal advisor, you have follow-up on clause 136. Thank you. New 2A of section 64B, we have made an inquiry with the government in relation to this clause. Now, if an insurance intermediary has breached this new requirement, what is the consequence? Because in subsection 6 of 64P, a licensed insurance intermediary who contravenes section 3 commits an offense is liable to a fine. And the administration's response is new section 2A or a breach of 2A is not a criminal offense. So members, please note this fact and consider whether it is an appropriate arrangement. IA, we agree to this policy arrangement. Thank you, Chair. A follow-up. If it is not a criminal offense, can the administration clarify? Now, if this duty to notify is breached, what will be the consequence? We will impose disciplinary action by IA. It is not a criminal consequence. So we may impose disciplinary sanctions. Yes, we may impose disciplinary sanctions under the authority of the IA. Okay, thank you. Page 304 of the marked up copy, 137 of the blue bill, section 72, licensed insurance broker company must appoint auditor. Under section 64, 7A, it must be done within 1 month after being granted a license. So in B, we have included that a person or Hong Kong other than a domiciled company will not be included. Clause 138 is section 78 of the insurance ordinance. It is about exemption under reinsurers. 3A says that a body incorporate appointed in Hong Kong, we've added a redomiciled company. And then in B, we have also added outside Hong Kong other than a redomiciled company. Clause 139 of the blue bill, it repeals company incorporated in Hong Kong under the definition of insurance holding company in Section 95A, so that this clause will apply to a redomiciled company as well. Page 307 of the marked up copy or clause 140 of the blue bill. Specified decisions under Schedule 9, we have added 1AA about objection to a non-Hong Kong insurer to become a redomiciled insurer. So this decision is subject to the review of a magistracy. Page 308 of the marked up copy or clause 141 of the blue bill. Consequential amendment to Rule 21, the definition of applicable accounting standards. We have added a redomiciled company to a Hong Kong company. Page 316 to 355 of the marked up copy. Clause 143 to 154 of the blue bill. Amendments to the Inland Revenue Ordinance. Page 136, Clause 143 of the ordinance amends the definition under Section 2. Ms. Carmen Ken. Before we move on to the Inland Revenue Ordinance, we have amendments to the insurance ordinance or insurance rules. I'd like to know whether you have consulted or received views from the insurance sector, because you made it sound like consequential amendments. I'd like to hear from the insurance sector. I'd like to know whether the insurance sector welcome this mechanism. And they will have to deregister elsewhere before they can be redomiciled insurer in Hong Kong. Now, we have consulted the insurance sector. Some companies hope that with the passage of this bill, they can activate their redomiciliation process. So we have made consequential amendments to the insurance-related legislation so that the requirements can be clear in the relevant legislation, and they know what rules to follow. Now, in the insurance-related legislation, we're referring to insurers with most of their business conducted in Hong Kong. So they will have to comply with they already complying with the requirements under the bill, so they have no objection to our proposed amendments. What about capital, group capital? Starting from page 309, that is amendments to group capital. Now for the three designated insurers, they are already insurers incorporated in Hong Kong, so they will not be subject to the to any additional regulation. We have made a lot of amendments to domiciled countries. For instance, 131, 132. I'd like to know whether once they are redomiciled in Hong Kong, they will become Hong Kong insurers and Hong Kong insurance groups. And the rules on capital rules will apply to them. Is it correct? It's similar to non-Hong Kong companies in re-domiciliation. Now, the 3 groups in Hong Kong already registered or incorporated in Hong Kong, so this is just a technical amendment. If overseas corporations would like to re-domicile in Hong Kong, of course, they will have to obtain licenses from us, and we will have to vet their capital and asset before we give them our approval. So there aren't any insurer waiting to domicile to Hong Kong. These amendments are technical in nature. If in future overseas insurers would like to re-domicile in Hong Kong to become specified insurers, they will have to follow these provisions. All right. Marked up copy 361 clause 143 of the Blue Bill. We've added the definition of re-domiciled company here, and we've also added reference to in this ordinance to a company or entity established or incorporated in Hong Kong includes a re-domiciled companies. And a reference in this ordinance other than sections 17A and 58 to a company or entity established or incorporated outside Hong Kong does not include re-domiciled companies. And for comprehensive agreement, now we will include a company incorporated in Hong Kong, and if it is entity incorporated outside Hong Kong but regularly controlled in Hong Kong, then we will add this definition. So in explaining the agreement, then such companies will be considered companies incorporated in Hong Kong and they become resident in Hong Kong. Page clause 144. Section 17A. To follow Basel III, we have definition of regulatory capital security. We have the definition in section 17A1. So other than a re-domiciled entity as defined by this section, we are talking about an instrument. And a company incorporated outside Hong Kong will not be covered. Now, under the banking ordinance, an authorized institution would cover banks and licensed companies and also limited deposit-taking companies. They will be considered incorporated company in Hong Kong, also a re-domiciled company. So we have to amend the definition of regulatory capital security under this ordinance so that the IR ordinance and also the banking ordinance are aligned in terms of regulation. And we will go into details further down the bill. Page 319 of the marked up copy or clause 145 of the Blue Bill, Ms. Carmen Ken. Now we're told that in on page 316 or 319 of the marked up copy, now they will be defined as Hong Kong residents from a tax perspective. In Hong Kong, we mainly look at the source of income. We don't usually define whether an entity is a tax resident. Is it because of BEPS 2.0 that we have to use this concept of tax resident? 多謝主席。
Any response? Thank you. Let me give an explanation. We want to make sure with the proposed amendments, re-domiciled companies can be covered by comprehensive avoidance of double taxation agreements, CDTAs. CTAs are only applicable to Hong Kong tax residents. Redomiciled companies with the proposed amendments will be regarded as Hong Kong incorporated companies. Therefore, we need to make the CDTAs applicable to them as well. So it is not relevant to the implementation of BEPS 2.0. It's relevant to the implementation of CDTAs. That's why we need to introduce a definition for redomiciled companies to be tax residents of Hong Kong. Alright, we are now halfway through the session. At 5, we will take a 5-minute break and then we'll resume the meeting after 5 minutes.